time in India as far as businesses, new companies, growth in terms of potential. But on the counter, we've also seen a lot of scams, a lot of shareholder disputes. We've seen a lot of issues when it comes to governance. So we've had, the government, through committees, through various exercises, where it's trying to figure out what needs to be done in terms of trying to counter that. So today we have a new Companies Act of 2013, which has actually tried to maybe regiment the way the board functions, place a lot of restrictions on how the board has to operate, and also give a lot of guidelines as to what the directors need to do to efficiently function on the board. I think before we get into what the appointment roles and responsibilities of the directors are, we need to understand what is a board. What is the responsibility of the board as we understand it as on date. So first, if you look at, coming back, which I referred to earlier, the Narayan Murthy report, it talked about corporate governance being the ethical conduct of business. It talked about corporate governance being beyond the realm of law. It stems from the culture and mindset of management and cannot be regulated by legislation alone, which basically comes down to our, as you correctly put it, our moral ethics. So that is how businesses used to function. I mean, if probably our grandfathers or great-grandfathers looked at it, business was about ethics. It was a personal responsibility that you held to people who have funded you. And that is where the board of directors came about, being the gatekeepers to basically protect the rights of the shareholders. Again, legal definition of board of directors, they're the trustees for the entire body of stockholders, and both good morals and common law. This is something which you'll find in, which has been defined in under law. And then again, coming back, what are the, then we had disputes, okay, what is the responsibility of a board? How do we safeguard the shareholders' interests? Then came the concept of fiduciary duty, that the directors have a fiduciary duty to its shareholders, and this has been something which has been reflected in various decisions of the court, and more recently also in the Supreme Court has also been voicing that. So this is the background and backdrop of which you had the Companies Act. This came through regulation. I mean, all these issues came through decisions of the court. They came through what the government decided, but it was not codified, it was not regulated. So today you have the Companies Act, which has codified the obligations of directors vis-a-vis the shareholders, and it's not just limited to shareholders. It is to do with companies and other entities with whom the company has relationship. So the obligations of directors is now not only limited to the shareholders, but they're also obligated to other people with whom the company deals with. Now coming back to how is a board going to be constituted? Companies Act today talks about you have two different kinds of companies. You have a private company, you have a public company. In a private company, you need to have 2 directors, a minimum of 2. In a public company, you need to have 3. These yardsticks continue. There's been no change in it. However, because a new concept has come into the Companies Act of a one-person company, a one-person company is a single-man show, so therefore you have the requirement of having at least 1 director. The permission to expand your board. Today, after a point, you had to go to the government to expand your board size. That has been done away with. It has become simplified, and now you need to get the shareholders' consent to expand your board to anything which is beyond the mandatory limit of about 15. So today you can go up to 15 directors. Your articles can provide for it. No issue, but if you want to expand it beyond 15, you have to get the approval of your shareholders by way of a special resolution. When you start a company, who are going to be your first directors? The first directors typically today, when you go for incorporation, you file who your first directors are going to be. What it contemplates is that your articles will specify who your first directors are. But if your articles fail to specify who your first directors are going to be, then the assumption is that whoever are the subscribers to your memorandum will be the first directors of the company. This is very well said in a rule book, but especially what happens when you have the subscribers to a memorandum who are going to be body corporates. So this is an issue which you're going to probably find, and maybe the rules will probably address it, or as we go forward, there will be a requirement where you'll also have to inform upfront who your directors are going to be, irrespective of what the law says. Then coming next is, what are the different kinds of directors that a company needs to have? Today we look at, you have well codified things as you have a managing director, you have a whole-time director, you have alternate, additional, casual. And apart from that, now you have the new Companies Act, which recognizes small shareholder directors, where in a large public company you have a small shareholder, somebody basically who holds shares worth of a value of less than 20,000 rupees. So if a company can suo motu decide, or on an application of about 500 odd small shareholders, appoint from the small shareholders one person to be the nominee of the small shareholders. Apart from that, you have to have a woman director, and the requirement of having a woman director is, again, in case of listed companies it's mandatory. In case of unlisted companies, private companies don't have any such requirement as per the rules which are contemplated as on date. As sir rightly said, the rules, what final shape they take, we really don't know. But as of now, it's contemplated. Private companies, there's no requirement. But for public companies, if you have a paid up capital of more than 100 crores, you will also need to have a woman director. Apart from that, this is something that is required for all companies. Today, you can have a company with the entire board sitting overseas. But there's now a requirement that at least one director has to be somebody who's been resident in India for at least 182 days. So you have to have a resident director. In addition to this, independent directors, threshold sir has already explained, it needs to be somebody who is requirement of 1/3 of the board of a company to be independent, has to be, again, with listed companies, it is mandatory. In case of public companies who have a paid up capital of 100 crores, mandatory. Or if you have loans or borrowings which is in excess of 200 crores, again mandatory. What needs to be seen is that today the Companies Act has actually delved into mandating requirements for listed companies. How it pans out with SEBI's requirements under the listing agreement, and if there are conflicts between the two, has to be examined, because SEBI has also been prescribing requirements of independent directors, has been prescribing who an independent director is independently. So today, with you have the Companies Act and you have the SEBI listing agreement, we need to see what will be the conflicts and how each regulatory authority is going to address it, because these are two issues that need to go hand in hand. Who can be appointed as a director? You have to have a DIN. That is something which is there today. Going forward also, director identification number is absolutely essential. The directorship does not say how old you need to be, but one of the requirements is that you need to be somebody who's competent to contract. And therefore, the minute you become competent to contract, you get in the realm of the Contract Act, which says who is a person who is eligible to execute a contract. So therefore, you need to be at least of 18 years of age. You need to be somebody who's not of unsound mind, and you will need to fulfill the other characteristics that you should not be under duress or under any kind of threat. Apart from that, it prescribes that you have to be solvent and you have not applied for adjudication. The other thing is you cannot be a director of more than 20 companies. And in case of a public limited companies, you cannot hold directorships in more than 10 companies. So these are the criteria you need to satisfy to be a director. However, having said that, there are other reasons where you can be disqualified as a director. We will come to that in a little while. Apart from that, if you are going to be appointed as a managing or a whole-time director, you need to satisfy certain other criteria as well. Okay, you cannot be both a managing director and a manager, so you can be either of them. Your appointment may need to be approved, will have to be approved by the shareholders and maybe the central government if required. Further, you may be 18, you might be eligible to be the director, but you cannot be the managing director unless you're 21 years old. And if you're more than 70 years old, then your appointment will have to be approved by the shareholders by way of a special resolution. Further, you also have, if you are convicted of a crime for which you have been sentenced for more than 6 months, then you will not be eligible to be a managing director of the company.